This is our first litigation group presentation for the year on a virtual platform, so that we hope that you enjoy the format. Now, before we go any further, I'd like to begin by acknowledging the traditional owners of the land on which we're meeting today, which are the Turrbal and Jagera peoples. We would also like to pay our respects to their elders past and present. Now, the topic for today carries on from the significant occurrences in 2018, such as the Banking Royal Commission, then into some of the changes that we saw in the regulators in 2019. And we thought it would be quite topical now to look at what are the trends that we're seeing in 2020. And we're seeing quite a lot of activity from ASIC and the ACCC, whereas some other regulators have, during the COVID period, taken a little bit of a break, such as the ACNC granting a moratorium to a lot of charities in terms of responding to notices and investigations until the 31st of August. So there has been a wide range of things that we're seeing, but the regulators are certainly active, and our experience has been over the last 6 months that they've been particularly busy. Now, there's a question and answer function available for today's presentation, and you'll see in the right-hand side of your screen that there's a box there that you can provide questions. You're welcome to provide those questions to us, and we'll try and have a look at them at the end of the session. To the extent we're not able to cover everybody's questions, we'll certainly respond with an email to you later in time. But please don't hesitate to ask any questions. Now, the session is also being recorded today, and it will be available for you to look at in a day or so. Now, in terms of the panel, my name's Tim Jones. I'm a partner in the litigation group, and I have with me senior associates Dan Morosky and Luke Finesse, and also Ella Furlong, who's a lawyer in our group. Now, each of us has some significant experience with regulators, be it ASIC, the ATO, the ACCC, and the CCC, and also ACNC. So what we're going to try and do today is share some of those experiences with you from a practical perspective. So what you're going to learn today, we're going to talk about what are some of the trends that we're seeing from regulators and which of the regulators are being the most active. We're going to talk about what powers the regulators have and how they're going about using some of these powers. We're going to talk about what is an obvious question for clients is how can they push back in relation to requests when you get a notice or there's an investigation? How do you go about dealing with those requests? And then finally, given there is a great deal of activity of regulators, how do you prepare yourself in advance for regulatory action? So, for example, a lot of the notice requirements, there are very short periods of time within which to comply with notices. So how are you able to respond to those in a very quick and timely fashion? Now, in terms of the format for today, I'm going to give you a brief overview of the regulatory environment, and then Ella is going to talk about some of the common powers of regulators and how they're using them. Then Luke is going to talk about current trends we're seeing with specific regulators, such as the ATO, the ACCC, ASIC, and the CCC. And Luke has a great deal of experience with the revenue authorities in particular. And then finally, Dan is going to go through legitimate ways that you can push back against requests from regulators with some real live examples. And having played an active role in the Banking Royal Commission, Dan is well qualified to tell us about that. So then the regulatory environment, what are we seeing? Well, one of the first significant developments has been the potential erosion of legal professional privilege, and the regulators are certainly looking at this. In the case of Glencore, which Luke will touch upon, is a very good example. Other things that we're seeing is risk profiling. So the regulators are very active, and they're looking at what are their risks in terms of bang for buck. What are the cases that they can prosecute quickly and also send a message to particular industries? And this also ties in with corporate social responsibility. So the regulators are very tied to best practice, and also public opinion. So arising out of a lot of the Royal Commissions are regulatory actions being undertaken by regulators. Another good example is the ACNC, when there were concerns about what money which was donated for the bushfires was being used for. So that's another area where a regulator has followed what public opinion is looking at. In addition, obviously in the current COVID period, there has been a propagation of a number of problematic business practices and fraud associated with COVID, and that's certainly seen some attention from regulators as well. And then finally, we're seeing some fairly aggressive ATO and OSR, Office of State Revenue, debt enforcement, particularly in relation to chasing money that's overseas. So Luke is going to talk about that in the context of freezing orders and other similar matters. So now I'm going to pass on to Ella, who's going to look at powers of regulators.
So we've attempted to summarise the common powers that some of the key regulators that each of you deal with on a regular basis have, knowing that you serve many masters and those in the environmental space in particular we haven't necessarily covered. But the commonly used powers of likes of the ACCC and the CCC and the ATO include the power to compel information, the power to compel documents, the power to compel interview attendance, and also the power to seize documents and devices. This power is actually one that can be exercised by the Board of Professional Engineers Queensland, as well as the usual suspects of the ASIC and the CCC. In terms of the latter three items, the regulators will need to get orders from the court, but you're seeing that these orders are often sought by ASIC and the ATO in particular, especially when money is looking like it's going to be leaving the country or directors are looking like they might be leaving the country, which we acknowledge is a little bit unlikely these days in a COVID-19 world. We've observed this increasing trend for the powers that are afforded to these regulators to be used frequently and with results. Most recently, a couple of weeks ago, NAB received a $57.5 million fine for a case brought against it by ASIC, as ASIC is beginning to, crack down on financial institutions for the charging of fees for no service. We know from experience that the ATO will use any item in their toolkit, including, as I mentioned, those freezing orders to make sure money doesn't leave the country. It's also widely accepted that the ATO is entitled to go on fishing expeditions when they issue these notices to compel documents and information without having the need to really have formed any idea about or expectation about the outcome or the relevance of what they're seeking. On this note, ASIC's powers were recently tested in the case of ASIC and Maxi EFC, which was trading as Europe FX. So here, ASIC alleged that Europe FX had failed to comply with the notice and sought general orders requiring that compliance. But firstly, I will note that Dan's going to talk about that a bit later in greater detail about the notice itself and push back, the ability to push back. But the judgment was clear that a notice issued under Section 33 of the ASIC Act, unlike a subpoena or discovery and litigation, really could be to go on a fishing expedition. And the court also found in this case that a notice wouldn't be invalid for failing to convey with sufficient clarity the documents that were actually required to be produced. In addition to these relatively standard powers like compelling information and compelling interview attendance, some of these regulators have quite extraordinary powers that are more akin to, the police or law enforcement agencies. And these can be used quickly and at very short notice, or even in a raid. So most notably is the CCC, which has extraordinary powers to engage in phone tapping or bugging, and even has the ability to hold coercive hearings, which require witnesses to attend and give evidence without even any entitlement to the privilege against self-incrimination. The ATO also has quite extraordinary powers where they're authorised to enter and remain on properties and premises with full and free access to books and records. Most relevantly and recently is probably the decision of Glencore, and Luke, I'm sure we'll touch on that a bit more later in greater detail again, but in Glencore it was found that the ATO can even consider hacked documents in their assessments. So they're really breaking down the virtual door, much like they're entitled to in a physical sense. ASIC's also recently been afforded, or their powers, I suppose, have been strengthened by the Stronger Regulators Act, which came into effect in February. And Luke, again, will speak to that. But what we're seeing is the implementation of the ASIC Enforcement Review Task Force. And there's a likelihood that I guess, the initial steps to strengthen the powers of ASIC will continue as more of the recommendations coming out of that task force are put into bills and legislation. And then probably relevant to quite a few of you, particularly in the mining sector, is that there have recently been calls for an independent federal regulator to monitor federal environmental compliance. And that's come most recently out of a look into the EVC Act. It's a bit of a mouthful. And a review into that legislation. Now, the current government has said that they're not going to push for that independent federal watchdog, but we know that undoubtedly in the next election that could change things quite dramatically. So it's important to understand that in addition to the federal watchdogs like ASIC and the ACCC, some of the state professional regulation bodies also have quite far-reaching powers, like the Board of Professional Engineering Queensland. And so we know we have a lot of people in attendance today from the aviation and aeronautical space. And while you might be very familiar with the regulatory requirements of CASA, it's important to remember that also professional regulators like BPEQ will also have space in terms of the conduct of professional engineers working on sites with an access to Queensland. So I'm going to hand it over now to Luke, who's going to talk a bit about the recent updates.
Thanks, Ella. And when we talk about trends and what we're seeing from regulators, I think some of those extraordinary powers that Ella was talking about really come into focus. So I'm going to start with the ATO. What we're seeing even during COVID is a really aggressive and litigious ATO. This year has really been a bit of a two-speed ATO. We're seeing where they consider the high risk, and high risk particularly to the ATO means record of poor tax compliance or any assets overseas, majority of assets overseas. We're seeing quick action, freezing orders. We often say that the best or the most effective team in the ATO is debt management by far. Everything else is a little bit slower. And certainly this year, if it has been a high-risk case, then and you are deemed to be high risk, then you would have been hearing from the ATO throughout. The rest, if you're in a dispute that's been rolling with the ATO, no particular urgency, you may have found that they've been quite slow. That will be coming back, but we are seeing they're targeting aggressive deemed to be aggressive behaviour. The other litigation kind of feel that we're seeing from the ATO is a tendency to either settle early or fight to the end. A couple of examples we've seen. In one matter, a GST matter, we filed in the court and the ATO conceded within about 2 weeks. In another, we had it go to independent review, and they surprisingly, despite the significance of the matter, conceded completely on internal review. Put against that, we're seeing clients in the trenches against the ATO for coming 5-6 years, reversing concessions that they've made when the matter started, and trying, perhaps surprisingly, to take fairly assertive positions on walking away from public rulings or private rulings. So there's definitely a sense that if the ATO is in for a penny, they're in for a pound. And anecdotally, we're hearing that within the ATO, the message is if you wouldn't litigate it to the end, don't bring it. So if you're having trouble settling with the ATO, it may be because someone's decided that it should be made a test for new case law. We've touched on Glencore, both Tim and Ella mentioned Glencore. Obviously, Glencore itself seeking protection, so not necessarily a case brought by the ATO, but certainly one that was contested by the ATO. And I guess the real practical element, which you put a couple of pieces together with Glencore and how the ATO deals with information. So you have Glencore, which wasn't the ATO in the background with the actually unlawful act, but obviously they used those documents in the leaks, overseas leaks, that were unlawfully obtained. The High Court's now confirmed that there's no cause of action in and of itself of trying to shield yourself from privilege when the ATO has used it in that manner. And then there was some commentary around, well, we're protected because a court would still say that what the ATO's got is not admissible, and that's to be tested, whether documents like the Paradise Papers would be admissible in a court. But you also put against you the onus of proof. So the ATO is not held to proof, and you need to provide the documents that say that your assessment is excessive. And so it is a dangerous position to be in where the ATO's got documents and they need to assess you, and they will assess you because they're required to, and then you're required to show the documents just otherwise. From the ATO as well, we're seeing still key areas of focus being those offshore multinational tax avoidance fields, transfer pricing, offshore investment vehicles. We're seeing the Commissioner still want a lot of law and chasing cases in terms of non-resident capital gains, investment structures, and Part 4A. And again, the ATO's attitude towards you will also have to do with, as Tim was talking about, risk profiling and where they see you in terms of your historical tax compliance. I haven't put it on the slide, but one thing in the revenue context I also wanted to mention is the Office of State Revenue. There is a lot of overlap between the Queensland OSR and the ATO powers. There are some important differences as well. But one of the things I wanted to touch on is that the OSR is now more responsible in the sense of coming under the existing Tax Administration Act for royalties and royalty disputes. Anecdotally, we've heard that the OSR is certainly still getting their feet under the desk in terms of working out what this means and how the new legislation works. But there is new and pretty significant changes for how royalty disputes will operate in the future. For example, those of you that deal with royalties will know that it has historically been a tool of judicial review, but now it looks more like a duties or payroll tax style dispute where you look at everything again, and it's not necessarily just confined to judicial review. ACCC. We'll focus on competition law, although there are consumer law priorities. I think looking at the attendance list for today, perhaps competition law is the bigger piece. They're testing the misuse of market power. So that misuse of market power provision has been broadened. Previously, it included an intention test, so purpose or effect, and now effect. So they're have removed the need for the ACCC to prove any sort of purpose, looking for documents that explain why or inferring a purpose why. And the first cab off the rank, perhaps unfortunately for them, is Tasmanian ports. We could go into that case, but I think the main risk that it highlights for people that have market power is that's been set down for a 15-day trial, and they're in the middle of ADR now. So just even the costs of running these are fairly significant and involve a whole lot of costs. I think the thing the risk factors to flag with market power, asking things like, do we have market power? Ports and airports often think about that, and it's a priority, and it should be. But even market power in a certain geographical area can be a risk sign. And then if you do, or even if you're worried that you might, questions like, do we have people that only really buy and sell to or from us? one buyer, one seller is a risk factor, and any changes as well. Tasmanian Ports was really about, and is really about, in the case that will come out about, new charges and new incentives for dealings in a particular way that's offended the ACCC. They're also targeting specific areas, a little bit like the ATO. We're seeing digital platforms, Facebook and Google. Energy, ports have always been under the close scrutiny in financial services. Public procurement, spotlight on public procurement. Really what they're looking for is collusion in government procurement. And obviously, and I'll talk about this with the CCC as well, because it has a corruption angle as well, but from a competition law perspective, looking for signs of procurement. For example, I was reading in an update from the ACCC, they were talking about, for example, something that they might catch their eye. This was an example. 1 week before the close of tenders, the relevant industry association is attended by managers of all the firms that subsequently tender. So that was sort of it certainly wasn't the worst example in their guidance, but it sort of gives you an idea of the questions that may be asked around public procurement in a competition perspective. And on the consumer things, there's a lot of priorities here. Again, not all of them relevant to this crowd, but the one that I thought I'd point out, unfair contract terms, and also priorities around not only unfair contract terms, but unconscionability. ASIC had a case against Medibank Private that they lost in 2018, that anecdotally they weren't too happy about, particularly where the judges said that the conduct may have been harsh or unfair, but not unconscionable. And so that's brought changes not only in unfair contract terms, but in how they wish to see companies behave and the types of powers that they're asking to investigate those consumer breaches. A lot of other priorities. I should mention that we've hit the ones, or we tried to hit the ones that are relevant to this crowd, but there are a lot of other priorities, Facebook and Google, health-related claims and consumer products, and franchise code breaches, but we haven't gone through them. CCC. So there's been a move away from, I shouldn't say a move away, but we've noticed more of an emphasis on the corruption focus, which I'm calling moving from bikies to pollies. So we're seeing more politicians in the spotlight. I don't know if that's just because we don't act for bikies and never have acted for bikies. I'm sure they're still of concern and target as well. But we are seeing the corruption focus beefed up, and certainly that's coming through in the public guidance as well. New definition of corruption, or I should say new definition of corrupt conduct. When I say it applies to you, I'm not, probably could have been a bit nuanced, probably accusing our audience of something that's there, but what I mean is that it applies not only to the folks that are used to these rules because they have government employees or fulfill a government function or report to government, but they're really broadening it not only to conduct of the public sector, but conduct that can corrupt the function and functions of government and damage public confidence. What does that mean? Well, it's dealings with government. You and your conduct in terms of dealing with government. Here comes the procurement piece again. They're looking at collusive tendering and also having a look at the process of applying for government permits. Here we're really looking at fraud, but any sort of conduct that meets the definition of corrupt conduct, as has now been broadened and as now we're seeing the CCC apply. A couple of other projects, Operation Impala, that's really about the misuse of information in public sector agencies, more commonly known as leaks. So they're going after leaks, after some really high-profile leaks and some high-profile targeting of corruption and abuse of office offences. You've seen in the news, no doubt, this is of great grief to some politicians. I should say there that a number of them that are in the news have been completely cleared. but of course, from the perspective of your business, any sort of mention is not something that you want twisted into something more. And so I just finish on the CCC by saying, yes, it's not always the case that that these changes are of direct targeting of your business, but wherever you deal with government and wherever you deal with politicians, you obviously don't want the brand involved. We've seen also a lot of companies, particularly global companies, that have all manner of anti-bribery and corruption policies that apply globally, usually go much further than the CCC's rules, but it's always good to know where your policy sits in relation to the conduct that the CCC is looking for. We won't go through crime because we probably don't need to. And then ASIC, last but not least, certainly, Ella mentioned stronger powers, aptly named Stronger Regulators Act, which strengthens ASIC's powers. I've said they're seizing, proving, intercepting and banning. So seizing not just books, but they can be more general in the demands and what they're asking for. The proving, this is really just about when they do seize the documents so they get the information, what they can use them for. So previously, certain categories of documents were for criminal penalties only. Now, civil penalty provisions are under the spotlight because ASIC can use the information for chasing those civil penalties. The intercepting part, ASIC hasn't been given an interception power. They can just use certain other agencies' information in their investigations. So it's part of a trend. I mean, the ATO can do it, the CCC can do it, but it's part of a trend of being surprised where one information has gone to one regulator and popping up with another. The machinations in the background are the types of things that ASIC now has the power to do. And banning orders, well, there's more banning orders. They're chasing banning orders post-Hayne. And certainly they'll continue. They've got broader powers. They can ban more people, and they steadily are banning more people. We're seeing well over 100 people banned about every 6 months. That slowed down a little bit, but certainly in 2019 it was at about that rate. It's steadily increasing, and post-COVID we expect that to increase, which is what my next point, COVID, the priority was for bad eggs, but Hayne is coming, I think is the headline. So ASIC adjusted its priorities in about March this year. So obviously, because of their stress with their staff or stress with resources, they really had to focus on the very bad guys, as they see them. So markets are always a big one. So think manipulation and abuse of markets. And protecting vulnerable customers. So there have been a lot of scams. Their focus has been on that COVID fraud that Tim was talking about. But now we're seeing and we're expecting that the Royal Commission recommendations are still very much in the pipeline. And so we've suggested that Hayne is certainly coming. Bit of a dip when it came to ASIC sending those requests for information and requests for information, requests for documents. We saw our clients getting less during the pandemic, and now it's picking up again. And again, it's because of that Hayne Royal Commission, the need to get more information to fulfil those recommendations. And we're also seeing ASIC, like the ATO, testing privilege. In fact, the ATO has been taking assertive positions behind the scenes and in guidance. ASIC's actually been in court more, the federal court more, testing it and winning, I must say, not in every case, but Dan will go through some of the cases that they have been successful on. They see privilege claims as claimed too much, and so they're interested in getting more on the bounds of that privilege. Finally, I wanted to cover some common mistakes that we're seeing in how people deal with regulators, perhaps with reference to some of the common attitudes that we hear. That's all privileged. And I won't cover that in detail. It's just really because Dan will talk about privilege and the excuse to production. We're seeing people claiming privilege on fairly questionable bases. And the other problem is that we're seeing people not being able to prove privilege in court in the correct manner. So even where privilege claims might be good, not having the right evidence or the right person signing the affidavit can be the difference. And so that's all privileged. It is open to challenge. We're not the bad guys. It can be easy and tempting to think about this when we're talking about fraud and bid rigging and anti-avoidance, anti-tax avoidance. I think that's about other people. We've got the systems in place, so that doesn't really apply to us. There's a couple of points to think about that. As most people will know, there's not too many industries that aren't under pressure and aren't under public scrutiny, and the politicians, through one or more regulators, have been having a close eye on. So I think the idea of industries that are seen as, beyond are slimming down. And the second point that I'd say about that is that because of the ways the rules work, for example, with the ACCC having misuse of market power expanded, it is starting to encroach into, it's not necessarily an intention to do the wrong thing, but the effect to do the wrong thing that is really what's catching people and bringing them into some grief. This is too small for them. A common mistake is to think that regulators will necessarily think totally commercially, that they'll see a bag of money and just work out whether it's worth chasing or not, forgetting that the regulators may have hundreds, if not thousands, of other cases that fall behind yours. The Chevron litigation, transfer pricing, was a very good example of that. You don't want to be the one that's paying the bills for the test that everyone else will follow. So sometimes dollars doesn't matter. There was an interesting one in the Office of State Revenue in Queensland, litigated one this year. The amount of money involved was $4,300, and they took it all the way through the Supreme Court. And the judge was noting of the fact that it was much smaller than you'd usually expect, but no doubt the Office of State Revenue considered it a test case that was important to run. And finally, everyone knows what happens. But what we're seeing when it comes to going to court is that folks aren't necessarily armed with enough affidavit evidence, with enough clear litigation-ready facts, and have not done the internal review to solidify the facts that they've always assumed that they could run when they get to court. So it's very important at the early stages of litigation to make sure you've done your internal review, make sure you know where the documents and people are, and really ask from an evidence judge lens, could we prove this if we needed to later on? And I'll now pass over to Dan, who's going to talk about some grounds for resisting regulators' requests.
Thank you, Luke, and hello to thank you to everyone out there in cyberspace. I hope you're enjoying the topic. I will admit it is one that I had a little bit of a hand in picking in because I have a fairly strong regulatory background. Before I joined private practice about 5 or 6 years ago, I spent about 7 or 8 years working for regulators at various places, both here and overseas. And when I did move into private practice, I was accused by them of joining the dark side, although I'm not quite sure that it's in fact that way. It might be the reverse. And just reflecting on my time sort of dealing with regulators, had a bit of an epiphany this morning. I haven't shared this with my fellow presenters, but some of you in the audience will know that I have a 7-week-year-old daughter at home, and I was reflecting on the similarities between a very enthusiastic regulator and a screaming baby. So some of the commonalities might be they're very demanding. They certainly don't take no for an answer. You often feel that you're stumbling around in the dark trying to give them what they're looking for, and then finally, even when you do find what you think they're looking for, they never quite seem satisfied. So if I put the bad dad jokes aside, as Luke mentioned, I'm going to now focus on some legitimate grounds to, in fact, resist regulator requests. And I'm going to do that by focusing on some of the real-life practical examples that Tim and the team here we've worked on the past few months. So essentially, what can I do when I receive a notice? How can I resist this? And in the same way that each regulator's got different powers, they also have different, excuses or reasonable excuse mechanisms built into their legislation and how you might be able to resist production. Some of them include legal professional privilege, which is fairly common across the board. Public interest immunity is an interesting one, pardon me. Confidentiality, self-incrimination. What I've put on the next slide is out of scope. Some people have tried to challenge the scope of a notice, either it's too broad or not clear enough. My advice would be don't go down that path. Certainly some have tried in this case that Ella mentioned earlier of Maxi FX, also trading as Europe FX, attempted that. And you'll see up there that they attempted to essentially resist handing over materials on a number of bases. The first one was whether or not the notice was invalid because it lacked sufficient clarity or was unreasonably broad. And I might just quickly read out what the judgment said on that. Essentially, the term that was being used here was the notice referred to documents recording or referring in describing the documents. And the court acknowledged that where a notice is couched in such wide and general terms that a proper exercise of the investigatory power could not support the requirement in question, it would be invalid. In rejecting the Europe FX argument in this case, the court noted that notices such as a Section 33 notice from ASIC under the ASIC Act are to be reasonably and not preciously construed, and that the validity of the notices should not be approached carpingly, was the word the court used, by engaging in a narrow analysis of each word in an attempt to try and find some latent ambiguity in it. So essentially what that means is don't try and narrow the notice. If you're not sure, speak to your regulator essentially and try and get that clarity that you're looking for. The next objection they tried to raise was whether or not the word possession meant documents in their physical possession. That was no, which moved on to, well, does it extend then to, if it's in our custody or control as well, does that extend to documents which are with some of our third-party service providers overseas? And in the facts of the case, it was shown that there was no restriction on Europe FX actually asking these service providers to give the documents back to them. And again, they should be handed over. Another objection was, did Europe FX nevertheless have a reasonable excuse for handing over the documents? And I hate to tell those of you asking the question out there that the inconvenience and expense of responding to a notice is not a reasonable excuse, and that was one of the ones raised in the case. And finally, there was sort of a broad, can we nevertheless have this knocked out? And the court said no. So as I said at the start of this, I suggest that where you've got issues on the scope of the notice, rather than just look to avoid it, speak to your regulator and try and come to a compromise position. And you'll see in some of the practical examples that we've actually been able to do that. But I'll move now into legal professional privilege. And as I said earlier, it's pretty much broad across the board with all of the regulators that where a document is legitimately subject to a claim for legal professional privilege, you can't be made to hand those documents over. However, that's being put to the test. So you'll see here that ASIC have a phrase in their notices that accepts that a valid claim of legal professional privilege is a reasonable excuse for not producing books under a notice. But a person who claims legal professional privilege must establish that that privilege exists, so the burden of proof is on the person claiming it. And what now ASIC have put in, and as a practical tip, this is quite a laborious task. They've essentially required that you have to prepare quite an extensive schedule listing all the various metadata that sits behind a document, so the names and authors of the recipients of the documents, the date, the type of document, the category of LPP claims, the names of the persons who are receiving the documents, including CCs and BCCs, where they work, what their job title is, the address of the premises where the document's kept, and whether the document is claimed over a whole or part of the document. So if you're only claiming it over part of the document, ASIC would still expect you to produce that, albeit in a redacted state. So that's quite a bit to work through. I thought I'd put up a bit of a worked example on what a privilege schedule might look like. So you'll see here, this is an example of a privilege schedule of which you would hand over at the time of producing your documents in response to a notice. So you'll see here that this privilege schedule speaks about 2 documents. The first one is an email, which is, you'll see the prefix there, CLU for Clayton Utz. It's dated today. It's actually dated at 1:30, so right about now. The topic is legally privileged and confidential. How do I rate today's presentation as excellent? And that's an email that's been sent from Zoe Gifford, who's at Allianz, and hi Zoe if you're there. She sent that to Kiralee from our clients and markets team. She's copied me in, and that document's been marked as privilege for advice privilege. And then the attachment to that document, which is the Clayton Utz feedback form, which has been authored by Emily Flood from our clients and markets team, has been attached. It's been marked part privilege, again for advice privilege. So this is what a privilege schedule now looks like and what ASIC expects. On its first tab, the second tab, it requires the authors, recipients, their titles and roles in the company. Now, if we go back one slide, you'll see that some of the claims for privilege here are probably unlikely to be successful, and I think that kind of leads into the next point that we were talking about, that ASIC are in fact challenging this quite a lot, and this is a judgment, the ASIC and RI Advice Group judgment that came out earlier this month. So here, RI Advice, which is a subsidiary of IOOF, claimed privilege over an internal report. The internal report was prepared at the direction of an in-house lawyer for the purposes, it said, of the lawyer giving legal advice. Now, I won't say so far so good because there is some concerns about in-house legal preparing reports or requesting reports and the dominant purpose test being met, but we won't dive into that now. But what we will move on to is where things started getting a bit troublesome for RI Advice. Firstly, a redacted version of that document, the report, redacted confidentiality, was actually handed over to the Banking Royal Commission. And if you were to jump on the Banking Royal Commission's website now, you could find that document. The second problem that they had was that RI Advice actually handed over a number of copies of the document to ASIC in response to notices, and at the time of doing that, they never claimed legal professional privilege over it. ASIC then used that report to instruct an expert. The expert made opinions on that report. The expert report was then tendered in the proceeding. So as you can see, there is a number of issues where a subsequent claim for legal professional privilege was always going to be tricky. In the end, the court determined that the report itself was not in fact created for the dominant purposes of legal professional privilege, but even if it had been, there were so many examples of waiver that the orders that were made basically saying that these documents had to be handed over. I'll touch very quickly on something that's not legal professional privilege, but it's a very particular privilege for accountants and board papers concessions, and this is an ATO specific thing. It's much more narrow than LPP. There's a specific form that this needs to be claimed under. There's a few carve-outs, and I won't dive into them into details except to flag this for you. I think the takeaway, and there's a couple of them, is really talk to your tax manager. This thing is very specific, but don't be mistaken thinking that it is legal professional privilege. Moving on then to confidentiality as a potential reason to push back on a notice. Different regulators take different approaches. So ASIC is actually silent in its notice on whether or not confidentiality is a reasonable excuse. Our practical approach to when we get notices of this kind is to basically flag in the cover letter and the response saying the material produced includes confidential material. We would seek that ASIC allow us to make submissions. Should it be the case that ASIC was minded to publish any of the documents or confidential material, and so far that's been a pretty successful approach with them. The CCC is slightly different. In their notices to Discover, they actually say that confidentiality is a ground for privilege, and that confidentiality in their case means something recognised at law or an oath or a commercial obligation. So potentially a trade secret, the CCC will allow you to resist producing a document on those grounds. Workplace health and safety legislation is very interesting. They built into their legislation a protection that any of their staff who receive confidential information are basically bound, and it's an offence for them to disclose any commercially sensitive or confidential documents improperly. So what they then say is that basically builds a protection is that you should be confident that you can hand over your commercially sensitive documents. And that includes things like board papers, which are always, we know for our clients, very concerned to be handing over board papers, particularly where there's issues that are very wide-ranging, have nothing to do with workplace health and safety. And the approach in the case of Perulia that's mentioned there was that the company receiving the notice attempted to redact the board papers and only hand over the bits of board papers that related to workplace health and safety. But the judgment actually sort of took a holistic approach and said, well, the fact that board papers are dealing with everything other than workplace health and safety may itself be a bit of a concern. And again, apologies for reading out the quote here, but the quote is that there is no basis, in my opinion, for the proposition advanced for the plaintiff that Section 155 is to be read as subject to a qualification or limitation that the person to whom a notice is addressed has an unrestricted right to determine for himself or herself whether documents have a connection or a sufficient connection with the matters under investigation. So essentially, you can't be deciding that it shouldn't be handed over, and you need to be relying, having confidence that the offence provisions on the staff will prevent that from being handed over. Not a perfect solution, we understand that, but it is what it is. The case law supports that. The next one is a grounds of public interest immunity, and this will be one that will be known better to some clients than others, but public interest immunity generally is governed by both the common law and statute. So you'll see that I've mentioned that the CCC has built into its legislation that privilege includes a ground of public interest immunity, including, say, cabinet documents, national security or defence materials, police informants, disciplinary hearings. So there is an acknowledgement, at least by some regulators, that public interest immunity is a legitimate ground for not handing over a document. However, a lot of the notices that we see just don't say anything. Reasonable excuse hasn't been tested in this area, and it's a bit of a watch this space. I guess the closest thing we've seen is the powers that the Royal Commissions are given under the various commissions of inquiry legislation, where you don't have to hand over information if you have a reasonable excuse. And there's been successful claims brought during Royal Commissions to not hand over materials. The reason I say watch this space is one of our clients was recently issued a notice. We resisted production on the grounds of public interest immunity, and so far haven't had any pushback on that, but that may change as the regulator starts diving a bit more into it. Final ground which I wanted to cover was self-incrimination privilege, and it's usually specifically abrogated by legislation. So you'll see the various sections there on the slide: the ASIC Act, the Workplace Health and Safety Act, various sections of the CCC's legislation basically say that a person is not entitled to remain silent, refuse to answer questions, hands over documents on the ground of self-incrimination privilege. However, if you claim it, that answer is not admissible as evidence in criminal or civil proceedings against you as an individual. That's other than, of course, in relation to false or misleading statements. So here we're talking about perjury. One little thing, if you ever, and I hope you don't ever find yourself the recipient of a CCC notice, just check whether it's a Section 75 or an 82, and I'll show you shortly what I mean. But one allows you to essentially take a blanket claim for self-incrimination privilege at the beginning of a hearing, whereas if you turn up for an interview, you have to claim privilege over every answer that you're concerned might dive you into that area. The ATO is slightly different, as mentioned on the slide. There's no specific abrogation of the privilege. However, the case law has certainly suggested that the penalty provisions for avoiding producing documents in fact mean that self-incrimination privilege can't be claimed. An interesting one is the Professional Engineers Act. It actually goes on to say that it is a reasonable excuse not to give information or answer a question if giving that information or answering the question may intend to incriminate you. So, as I said, every regulator has a slightly different approach, but you just need to be conscious of it when you receive those notices. Speaking of receiving them, I'll quickly fly through some of the notices we've seen on more recent times. Here's an example of a Section 33 notice from ASIC. So I've kind of highlighted some of the bits here which we've mentioned previously. So the company is not excused from producing books on the grounds that the books may tend to incriminate or expose it to a penalty. ASIC accepts that a valid claim for LPP as a reasonable excuse for not producing the documents. However, you'll see there at A, B, C, D, E, F, G, H, this is the schedule that I talked about earlier that you've got to, these are sort of hoops you've got to jump through if that's something you want to claim. You'll see the notice itself basically says, in relation to the following, an investigation into the following breaches, bang, 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 you are required to produce the following books. It includes drafts, you'll see, and then this is this sort of wide capture-all thing, all books recording this, all drafts, all communications, all final versions, final drafts, including but not limited to. So again, this is this language which is designed to be all-encompassing and can't really, as the case law suggests, be objected to, unfortunately. The next is a couple CCC examples. So this is a notice to discover in a corruption investigation. You'll see here highlighted at the top that this document is highlighted as being a confidential document. Essentially, that's got a defined term and means that you can't talk to anyone other than your legal advisors about that document or, in fact, the investigation. But you'll see that the notice hereby requests an oral statement of information of the type specified in the notice and then documents relating to that bit of information. Obviously, I've removed all the important information, but you can see there that it says at the top, an offence is committed if the information, document or thing is not committed, if is subject to privilege or is a secret process of manufacture applied to by use for solely a lawful purpose. So again, your trade secrets. And they set out that privilege includes LPP, PII and parliamentary privilege, which we haven't covered, but we can if anyone has any questions. It also mentions confidentiality. Whereas at Section 82, this is the attendance at a hearing. So as I mentioned earlier, slightly earlier, you are required to attend the Star Chamber on this date, and you need to discuss your relationship or association with your professional, social, or otherwise relationship following, your indirect or direct knowledge of the following, your involvement in the following. Again, quite encompassing, and they're quite intimidating for those people who receive it. But again, we're quite experienced at all this and can help you through as needed. The final one I'll show you is, final two, is a workplace health and safety notice. And you'll see here this is in track changes. This is an example of where we push back on a particular notice and the regulator tried to confine some of the terms there. So they, where the notice initially just asked for all minutes, they were then comfortable enough that it only related to minutes relating to workplace health and safety matters. Again, the issue of redactions has come up. You can see they've requested unredacted copies, and helpfully they've even extended the deadline for compliance, which is increasingly harder to get sometimes. The final one is a notice from the Board of Professional Engineers. So for all those engineers out there or persons who employ engineers, you'll see that there's a bit of a crackdown by the board. They look for things like position, title, role description of any relevant qualifications and delegations held by all your relevant employees. So really what they want to know is that are your professional engineers registered? And if they're not, why not? The other curious one that the board asked for is at 4 there on the right, that when you supply documents, they've requested an Evidence Act certificate. Again, this is one we hadn't seen before. We push back on that, saying, well, an Evidence Act certificate only applies in certain circumstances and not in the circumstance of this notice. And we were successful in pushing back on that. So they're in a very quick way, and knowing we've only got 5 minutes left, I've dived through some practical examples there. I will throw over to any questions. see we do have one.
So we've got one, yes. It's noted to be a question for Tim, but I think anyone can probably speak to this if you guys want to jump in. So do you have any tips to seek, manage and claim legal professional privilege for in-house counsel advice specifically?
Yes, I've got a lot of tips, and that's almost a presentation of itself. But I mean, distinctly, the key to maintaining legal professional privilege in relation to advice by in-house counsel is making sure that you satisfy the dominant purpose test. So, for example, if you're asked to provide advice about whether or not your particular company may have breached a contract, you need to be very careful about the communication. So if you require a copy of the contract and all of the correspondence, you might send that to the business and you might say, for the purposes of me providing legal advice in relation to the contract, I require the following documents. That will mean that all of the communications coming back to you, providing those documents to you for your analysis, will be subject to privilege. You'll then provide your advice, and then you can say, my advice in relation to the contract breach is X. The next thing you need to do is be very careful about the distribution of that advice. You need to be mindful of people in commercial positions, for example, saying, we got this advice in relation to this contract where we breached it. So in future, to make sure we don't, these are the things that we need to do. That particular email or correspondence is not going to be for the dominant purpose of legal advice. It's for a commercial purpose, so it's not going to be privileged. So the real key question is for in-house counsel to maintain control over the communications, and then also the distribution, provide clear guidance to people in the business, what they can and can't do with the advice. So that's a quick set of tips in relation to that particular issue. But if you want some broader input in relation to that, or we've got a number of presentations that we can give you about that particular topic.
That's my only question.
Okay.
While we've got 2 minutes, the one thing I will say is when you receive a notice, be sure to check your deadlines, because one of the things that you'll have to build into your production process is these things like privilege schedules and objections and just making sure that you take the time to ensure that what's going out you're comfortable with, and we're finding increasingly that process takes quite some time. So if you're expected to hand a document over at 5 o'clock today, or a series of documents, you probably need to be ready to have done that the day before, just to build in that buffer required to make sure that all your ducks are lined up in relation to claims for privilege or whatever it might be. So that would be, I guess, a practical tip when you receive a notice.
That probably wraps us up.
Probably does.
Yes, well, thank you very much for your attendance today. And if you decide that you've got a question about any of the topics that we've canvassed, please don't hesitate to send any of the panel members an email, and we'd be happy to come back to you with our responses. So thank you very much for your time today, and have a good day.